invites a lot of intellectual but also moral dispensation when you begin to argue. First of all, let's first look at the mandate that gives these people the right to do what they do. It is very clear under the Uganda Public Service Order, particularly Section C, that they can, make provisions or make acquisitions for study leave and medical leave as they were. So the question we are propounding ourselves is whether or not the executive director, in her personal capacity, invoked the Local Government Act, particularly CAP 400 and 243, particularly Section 3C, Regulation 3C and Regulation J, where she says that she's now causing a notice of what? An issuance of a vacancy or, lack of, for calling for another provision for people to take up those offices. The question perhaps that delves deeper is, before these guys begin asking for these so-called study leaves or medical whatever, do they have projections within their hearts of what they intend to do? I'll begin by reminding them that solus lex propena, solus lex populi, meaning that the welfare of the people becomes supreme. If you are having this anticipation of doing a service for your constituency, have you envisaged, have you forecasted? Is it an act of God? Is it a force majeure that has overtaken you that you are unable to see what is likely to happen to you? Or is this something that is deliberately done to frustrate the organizations or the running of the constituencies?
Okay. Council, what I also want to understand is, look, they've been away for about 3 years, others 2 years. That's quite a long time. But their seats are not vacant. So no one can be re-elected in their seats because they're not vacant. The question is, the electorates are really losing out. They're not getting the services as stipulated earlier in the roles of any councillor. Where can the law be applied to deal with the situation?
Good question, and that's exactly what the executive director is trying to say. He's saying in the absence of the fact that you guys are not carrying out your jobs, and listen, even though you actually applied for leave, whether it is study or medical, there should be periodical reviews, there should be periodical appraisals that should be given to these people to the powers that be. But if these periodical reviews are not given, then the executive director has mandate to move and say, listen, I'm causing this office to be vacant because you are not executing your mandate as provided for.
All right, lastly, in just 30 seconds, moving forward, how should this study leave, sick leave be applied? Who should be approving it to avoid similar circumstances in the future?
Good question. Again, the question of substantiality vis-a-vis essentiality. I think that's the question that we should be asking ourselves. Before we give these so-called leaves to these people, can we prove, is there substantive evidence that these are really provided for, or are we simply, what I use the other phrase, like a fasanda parcel, people taking advantage and simply going for greener pastures and going and leaving these jobs where at the mercy and at the discretion, total discretion of the people. We are failing to manage business. Meetings are being aborted. There's substantially nothing taking place in these concessions simply because there's no quorum. This is the point that we need to be concerned as citizens.
Dr. Chris Logo, many thanks for speaking to us this evening. Is Law Don at Nkumba University.